Okay, we're back for Bill of Rights Part 2. We're going to take up Amendment 9 and 10 in the Bill of Rights now. And Amendment 9 is very, very interesting amendment. It says this: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And you say, what does that mean? The enumeration, the listing in the Constitution of certain rights shall not be construed to deny or disparage others that are retained by the people. Are you getting any clues? The Supreme Court has said what this means, of course they're telling us what it means, is that in amendments, all the first amendments and the first freedoms and on down through the Bill of Rights, and you get 4, 5, 6, and 8 are your due process guarantees. And there's a list of rights that you have. But what 9 is basically saying is that the Founding Fathers enumerated or listed the rights, but they might have missed some that they didn't put on the list. And just because it's not on the list doesn't mean that you don't have them. There may be some other rights floating around out there that you have and they didn't get on the list. That's really what they say Amendment 9 means. Now, what does that mean to you? Well, there are two major cases I want to tell you about. One is called Griswold versus Connecticut in 1965 and Roe versus Wade in 1973, which was a Texas case. Okay, Griswold in 1965 is a fascinating case. It was a Connecticut case. There was a state law in Connecticut which made it a crime to possess, use, sell, buy, or counsel to buy or use any contraceptive device. This is called the Contraception Case. So this is an old law in Connecticut. It was a crime if you bought something, pills or condoms or IUDs or any method of contraception, foam, gel, just go down the list. If you bought it, if you possessed it, if you used it, if you counseled others to use it, it was a crime that was punishable by law. There was a woman whose name was Griswold, and she owned a family planning clinic. And she had doctors and nurses working in the family planning clinic, and they were dispensing contraceptives. And she was arrested under this old law. Of course, Connecticut people were using contraceptives in the 60s, but the law wasn't being enforced. But some hotshot district attorney someplace decided that he or she would make their career on this case. So Griswold was arrested and convicted because the law was violated. The case was appealed, went to the Supreme Court in 1965. And the argument was litigated. The argument for the defense for Griswold was saying this: there is a right under the Ninth Amendment that we all have, and that is the right to privacy. There's no statement in the Constitution or Bill of Rights that you have the right to privacy. But I would bet that most of us really believe that we have the right to privacy from government peering into our affairs. And so she said, if government is peering into a bedroom of a married couple, in this case, most were married couples dealing with this, that is a violation of the right to privacy. And the Supreme Court bought that argument and established this concept of right to privacy with Griswold and struck down the Connecticut law back in 1965. Very interesting case. And then in 1973, and most of you know the name of this case, Roe versus Wade, this is called the abortion case. And many people believe that this gives you the constitutional right to have an abortion. This was not the way the case was litigated at all. This was a Texas case, and in 1973, the Texas law made it a crime to either have an abortion or provide an abortion for someone. So you could go to jail for having the abortion or for being the doctor or the nurse or the midwife or whoever it was providing the abortion. There was a woman whose name in this case was Jane Roe. That wasn't her name. You've heard of John Doe. Well, this is Jane Roe, and they did it that way for privacy. She was pregnant and wanted to terminate her pregnancy. Couldn't do it because the state of Texas made it a crime. And so she filed a lawsuit against Henry Wade, who was the district attorney of Dallas County at that time. And the case went all the way to the Supreme Court. Two young women lawyers, Linda Coffey and Sarah Weddington, took the case, and they had just gotten out of law school, and they took her case because they were probably pretty cheap and very anxious to litigate a case like this. And they took it all the way to the Supreme Court. And the argument that they gave to the court was this: that a Texas law that prevents a woman from dealing with a pregnancy in her own body violates her right of privacy, that government should have no reason to be looking inside a woman's uterus, at least in the first and second trimesters of pregnancy. In the third trimester, government did have an interest in the woman's uterus because the fetus would be viable at that time. So a very interesting case that we see messed with and litigated with all the time today, and they're still talking about repealing Roe v. Wade or changing Roe v. Wade, and we see some Texas laws that just came out of this session of the legislature requiring waiting periods and perhaps other more invasive procedures before a person would have an abortion. So the Supreme Court over time has upheld Roe v. Wade, but they have also, closer to our time period, said that there can be some restrictions and just kind of holding it back in terms of abortion. So this issue will go on. Very important case. But the important point for us in the Bill of Rights is that it was litigated under this right to privacy, which is not written in the Constitution, but is inferred from the 9th Amendment. The 10th Amendment doesn't really have much to do with anything else or rights of us at all. What it says is this. It's called the Reserved Powers Clause. It says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. This means that if any powers that are not specifically given to the national government, or inferred under the Elastic Clause, are reserved to the states. So the states have all these powers, and you're hearing a lot in the news today and in the political realm about 10th Amendment rights, 10th Amendment rights. So this is the 10th Amendment. It's the reserved powers of the states, and the states have a huge police power and welfare power to take care of folks in their state. So that's the Bill of Rights, the first 10 amendments to the Constitution. A fascinating study, and I hope you'll read more and more about the Bill of Rights. It's so important to you and to me. Thanks a lot.